Welcome to my YouTube channel. Please like, comment, and subscribe. The difference between maintain and cure and the Jonas eggs. As a seaman with an injury from being on the job, you have more than one source of protection under the law. The major difference between your right under this law and those under the Jonas Acts is related to negligence. According to the law, your employer has a responsibility to compensate you, regardless of who. If anyone was at fault for your injury or illnesses, you have no burden to prove negligence on the part of anyone's, even your employers. And then about maintain and cure. Maintain and cure dates back to ancient time and is the idea that someone working aboard a ship has certain right if he or she is injured on that ship, regardless of any negligence. Work aboard ship is dangerous and risky, and it was long ago decided that anyone willing to work in this condition was entitled to certain benefits in case of injury or sickness. The ancient law has been passed down to modern times and current maritime law includes these provisions to ensure that injured seamen are given maintenance, money for everyday living expenses, and cure, payment for adequate medical care. If you are a seaman and you were injured on the job, you have certain rights guaranteed by this law. Your employer, regardless of negligence, is obligated to provide you with adequate compensation to meet this right. If you are not receiving what is within your right to get, contact a lawyer knowledgeable in maritime law to help you take the next step. Maintenance. Maintenance under maritime law refers to the cost of maintaining yourself and your daily life when you can't work, or in simple terms, room and boards. If you can't work and earn a wage because of an injury aboard a vessel, this aspect of the law entitles you to the money you need to pay rent and utilities, to buy food, to pay for insurance and taxes, and to cover any other necessities related to your home. The right to maintenance from your employer comes from the fact that a ship owner is responsible for housing and feeding you when you are aboard a ship. This extends to your daily needs when you are off the ship and unable to work because of an injury or sickness. Anything that is not a necessity, like a cable bill or gas for your car, is not covered under maintenance. The law is specific to household necessities. And then cure. Cure is related to your injury or illness caused by being on the job as a seaman. Whatever medical care you need as a result of that illness or injury should be covered by your employer under the law. This includes medical bills but also medications, transportation to medical appointment, and any kind of reasonable medical treatment, like physical therapy. Maintenance and cure for illness. This right does not apply only to injuries that occur aboard a vessel. Working on a ship is a dangerous and risky job, and accidents are not uncommon, but you can also get sick because of your work or simply while you are at work. Your illness doesn't have to be related to your duties or the environment of the ship. If you are too sick to work and your illness develops while you were aboard the ship, you are still entitled to maintenance and cure from your employer until you are well again. And then about the duration of benefits. The right to living benefits and care lasts until you reach what is termed maximum medical improvement or MMI. MMI refers to a point which you have been treated medically until your condition cannot be improved anymore. This could mean you are fully cured or healed, but it may mean that you are living with a chronic condition. Either way, your right to maintenance and cure expires when your doctor declares you have received MMI. And then the rate of benefit. The rate paid out for the right of cure to an injured seaman should be exactly when the medical expenses cost, not any less. There was a time when employer paid less than the actual living expenses for maintenance, but court cases challenging the practice of underpaying for maintenance were successful. Employers now must pay the actual living expenses of injured seamen. If you belong to a union, your contract may include a provision for the rate of maintenance that applies to all members, regardless of your actual living expenses. However, the law regarding union maintenance rate is interpreted differently in different parts of the country. A personal injury lawyer experienced in maritime law can help you figure out if your union membership affects or determines your maintenance rates. Thank you for watching this video. Don't forget to give like, comment, and subscribe.